Our lives are full of transactions, and every transaction or every set of transactions forms part of a contract. We deal with contracts on a daily basis, we deal with contracts in our everyday life. And let us understand firstly what are the essentials of a valid contract. Today we are going to do the 5 essentials of a valid contract. Firstly, let us understand what a contract is, and let's break it down as per the various definitions of the Indian Contracts Act. Very simply put, under section 2H of the Act, a contract is an agreement enforceable by law. Now, when we talk of an agreement enforceable by law, what is firstly an agreement? An agreement is defined as every promise or every set of promises forming consideration for each other. Now, to understand this whole thing of what an agreement is, and then of course finally what an agreement enforceable by law is, Section 2A of the Indian Contract Act says when a person signifies to another person his willingness to do or to abstain from doing something with a view to obtain the assent of the other person, such act or abstinence is said to be a proposal. Section 2B says when the person to whom the proposal is made signifies his assent to the proposal, this proposal, when accepted, becomes a promise. Then going back to that, a set of promises forming consideration for each other is an agreement, and an agreement enforceable by law is a contract. Now, while we're on the subject of acceptance of contracts, what is noteworthy is acceptance to a proposal has to be absolute and unqualified. What do we understand by this? If the acceptance to a contract comes with conditions, it would amount to a counter proposal and not to acceptance. Now, in cases of counter proposals, it would need to be accepted by the original proposer, not by the acceptor. It becomes a counter proposal, and the original proposer would need to accept those terms. Until there is an absolute and unqualified acceptance of a proposal, there cannot be a valid contract. Section 10 of the Indian Contracts Act spells out the essentials of a valid contract in very simple, very expressed terms. Section 10 of the Indian Contracts Act 1872 reads, all agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object, and are hereby not expressly declared to be void. Let us now understand the 5 essentials of a valid contract. Firstly, the free consent of all parties involved. When you say that consent is free, what you effectively mean is that consent is devoid or is in the absence of coercion, fraud, undue influence, misrepresentation, and mistake. Now, when you say misrepresentation, there should be no misrepresentation of facts, or there has to be no mistake of facts, which means it's very crucial to accept the same thing in the same sense. That's very simply mistake and misrepresentation put. Undue influence, of course, is where one person is in the position to dominate the will of the other. And coercion and fraud are more commonly known to most of us. Coercion, where there is any pressure of sorts put on a person to accept a contract, and fraud, of course, where there is an element of dishonesty and cheating. The next very important element is parties competent to contract. Now, who are parties competent to contract? By and large, every major is a person who is competent to contract. Section 11 basically states that anyone who is a minor, an insolvent, or a person of unsound mind is a person who is not in a position to contract or is not competent to contract. everybody else is competent to contract. One very essential element of a contract is the consideration in that contract should be lawful, or the contract should be for lawful consideration. This is very crucial because the consideration cannot be expressly forbidden by law or cannot be illegal under any law for the time being in force. This takes us to the fourth essential, which is lawful object. Now, while the consideration needs to be lawful, the object or the very purpose or the substance and the crux of the contract cannot be illegal or expressly forbidden by law. While the consideration for the contract needs to be legal, even the object of the contract needs to be legal. And the fifth one is expressly declared to be void. Now, when we say expressly declared to be void, it essentially means that it is not expressly declared by any of the provisions of the Indian Contracts Act or of any other law for the time being in force declared to be void. A very classic case of this embodied under this act is an agreement in restraint of legal proceedings or an agreement in restraint of marriage are void. These are cases where contracts made for such purposes are expressly declared to be void. Apart from these essentials, there are certain other factors that you would want to consider. Certain other factors that are essential to decide whether or not a contract is valid, whether or not it is void. Another very interesting fact that you would want to consider are the terms of the contract. The terms of the contract need to be certain, need to be defined. Contracts which are uncertain, contracts which are vague, could be void. Further, the contract or the terms of the contract should be capable of being performed. It should not be a contract for an impossible thing, a contract for something which is incapable or impossible to be fulfilled, incapable or impossible to be performed. With this, I hope you understood the bare essentials and do keep these in mind when you get into contracts.